Welcome to Uniquely Mia's Criminal Justice 101 Perspective and Policies course. In this class, we'll be going over the difference between administrative searches as well as criminal searches. As the name suggests, searches, these are searches that are conducted within the criminal justice system and by police officers. However, it should be noted that administrative searches are generally routine inspections of homes and businesses to enforce fire codes, health and safety guidelines, or housing codes. However, sometimes these administrative searches can fall under the realm of criminal justice if contraband, drugs, weapons, somebody who went missing was found. If a criminal activity or criminal substance is discovered during these administrative searches, they can fall under the jurisdiction of the criminal justice system. And then should be noted, when we think about criminal searches and seizures, which falls under the Fourth Amendment of the United States Constitution, a warrant is required to do this lawfully and ethically. However, in administrative searches, warrants aren't generally required, and there's a less strict policy or guidelines around the obtainment of a warrant. And within criminal searches, the purpose of criminal searches is to gather evidence related or about a crime. So when we think about these criminal searches, as I said earlier, to conduct these criminal searches ethically, we want a warrant. And to obtain a warrant, generally the police officer, they're going to submit all their information, write details pertaining to why they want the warrant, what do they think they are going to find when they search this house, or where do they want to search in the warrant. If they want to search an individual, who do you want to search in the warrant? The description, warrants with the description about why you want the warrant is generally written in an affidavit, and this has to be very, very detailed. And for example, let's say this warrant wasn't acquired, or a police, they violated the terms of the warrant when they were doing the search. If an offender feels like they want to appeal this decision, they can do so in something known as a Frank's hearing. And Frank's hearing is a legal proceeding where a suspect can attempt to show a judge that the police officer intentionally lied or recklessly in the affidavit they used to obtain the search warrant. So the police officer within this Frank's hearing, to obtain this warrant, they probably lied to the judge intentionally, like to say, oh, I knew this offender had a drug before they even had the drug. That's essentially lying in the affidavit to get evidence to search. And it should be noted, as I said earlier, warrants specifically for criminal searches are very detailed. So in a warrant, if an officer specifies that they want to go and search for a missing guitar, right? You know, a guitar is pretty big. And let's say they enter the defendant's home and they're opening drawers where toiletries may be. That is a violation. You're violating the scope of your criminal search warrant at that point, because you know a guitar cannot fit in a pantry or a cupboard, a small cupboard where you keep your toiletries. So that's a violation. If administrative searches are generally conducted by health officials or housing officials to make sure that landlords and restaurants are up to code, oftentimes officers are not going to be conducting those searches with individuals. However, they have something known as the plain view doctrine. And this plain view doctrine allows evidence of criminal activity discovered in an administrative search to be used to obtain a valid criminal search warrant. So within this plain view doctrine, let's say a firefighter is conducting a search. They enter the unit, they see drugs. They call 911. Officers, when they call 911, they're generally, it takes a while to obtain a search warrant, so generally they're not going to obtain a search warrant 1, 2, 3. However, since they got this phone call from the firefighter, they're going to go into the unit, they see the drugs. Per this plain view doctrine, during this administrative search, they can take this evidence and then they can go to a judge and be like, hey, I need a valid search warrant to search this unit to see if they have more substances. There's also something known as the special needs doctrine, and these are where searches are evaluated under the reasonable reasonable standard of the Fourth Amendment, and these are directed towards individuals. So it's saying perhaps special needs doctrine is things like searching cells within a correctional facility, or perhaps you're searching a student in a school, things like that. Those all fall under the special needs doctrine, because when you're in prison, like when you're incarcerated in a correctional system, they do not fall under the Fourth Amendment right to protect searches and seizures. So like me, you guys as individuals in society, if a police officer were to pull us over on the side of the road and ask to search us, they have the ability to do that. However, generally do need a search warrant if they need a reasonable suspicion that they're going to find illegal activity. If they stop us and be like, hey, I need to search you right now, they need to have a reasonable suspicion that you have an illegal substance or something in your vehicle or on your body to search you then and there without a warrant. However, 9 times out of 10, they need a search warrant to search us because this falls under our Fourth Amendment protection. However, when you enter the jail and the prison facility, specifically for offenders, they don't have this. This is given up because they are a special needs population. Since they are already incarcerated, they don't really own their space, if that makes sense. So correctional officers, they're allowed to search cells, and sometimes they're allowed to conduct strip searches at any point in time, as long as they have a reasonable suspicion that they'll find something illegal or that the offender is breaking a rule. And as long as it's conducted ethically and in a clean environment, they can do this. It should be noted that searches in schools are also allowed. However, strip searches are not allowed to happen within the school facility for children. This occurred because of a case known as the United School District versus Reading in 2009. This is where a school administrators, they had a student literally stripped out of all her clothes, and they conducted a search on her because they believed that she had drugs. So after this case, it essentially said that school administrators, they went too far in that case, and schools are not allowed to strip search children. However, schools do have the authority to search students' bags, and this specifically relates to elementary and high school schools. Elementary and high school schools have the authority to search students' bags, or to search like their school locker if they have one, if they have a reasonable belief that the student, that they broke the rules or that they have illegal substances. When we enter the arena of higher education, colleges and universities, generally, so universities, they have their own campus police officers, correct? So campus police officers, let's say they go into a residence hall and they want to search a unit. If the campus police officers search that unit without cooperation of the school officials, any evidence that they find can fall under the exclusionary rule and can be inadmissible in court. However, if in a university setting, specifically a residence hall, school police officers, they reach out to housing directors or a resident assistant like, hey, I need to search this unit. Do I have your cooperation? And if we say yes, school officials say yes, they can go into these units and evidence that they find could be admissible in court as well when we enter this arena. And then public and private schools. So when we get into private schools, like private universities, things get a little iffy because private universities, they may have their own rules on what they want to search. And even if it violates or causes some gray area, calls into questions the legality or the ethical behavior of that search, as if a student signs to it when they agree to attend that university and to live on campus, that school may be legally in the right to search a student whenever they want. As border searches, and this is essentially saying when I'm going into an airport through TSA, or if I'm going on a cruise ship, or if I'm crossing a U.S. border, these are the ultimate special needs search. This is essentially saying we are giving implied consent by entering these high security areas, that these people can search us. And if we say no, I don't want you to search me, then generally when you go through TSA, if you go through TSA and you're like, hey, TSA, I don't want you to search me, they're not going to let you get on that plane. So you have the option of leaving and not catching your flight that day. So there's something known as a public transit search. This specifically emerged in light of New York City subway checkpoint searches, and these are legal and it's upheld by the federal district courts. So this essentially means if I'm in New York City and a police officer comes up to me and like, hey, I need to search your bag. Once again, gray area with the Fourth Amendment. I could be like, hey, is this valid under the Fourth Amendment of the United States Constitution? But according to this public transit search, they have the autonomy to do that if they are working within MTA and doing so for the safety of the New York City Transit Department. And there's also something known as DNA searches, and this is essentially saying somebody committed a crime. We don't know who committed the crime yet, but forensics go to the scene. They take the DNA that was there and they can put it in a crime database that has like known criminals to see if like the DNA matches, and this is legal. So as I said, public safety searches, public safety areas, these are also like a form of special needs. So if we're doing a search for public safety, these searches can generally be conducted without a warrant. If you work for a government facility, they can also potentially conduct searches on you, or they can mandate it that you have to get certain drug tests. So let's say you work for the government railroad station and you're driving trains. It can be legal for that government, that organization to say, hey, I need to search you spontaneously, or hey, you need to take this drug test spontaneously because we're doing so for public safety. So this falls under the special needs category of a public safety search, and a warrant generally isn't required for this. Something known as probation officers or parole officers. So this is essentially saying somebody was incarcerated in a correctional facility, they're released back into society, then they have this probation or parole officer watching over them. In some states, so it should be noted, in states where probationers do not sign release agreements waiving their Fourth Amendment right, a probation officer needs a reasonable suspicion as to a violation of a probation rule or a crime to conduct a search. So they need a reasonable suspicion of this to conduct a search. However, in states where probationers waive their Fourth Amendment right, then these probation officers or parole officers can conduct searches whenever they want. And it should be noted, closely or heavily regulated businesses are things like mines, gun showrooms, liquor stores. So this is essentially saying that searches can be conducted frequently here because these are heavily regulated businesses where dangerous stuff can happen. More of the story is there are two main types of searches that can occur: administrative searches and criminal searches. As I said, administrative searches, the guidelines to obtain a warrant for that search. You generally don't need a warrant to conduct an administrative search. However, sometimes a warrant can be acquired, but it's less strict. You don't need to put as much details in it opposed to that criminal search where you need to be very detailed, very specific, and make sure you're not lying. Make sure you're not, when you're conducting that search, you are not going outside of the scope of that search, because if that happens, evidence that's found could be deemed as not admissible, fall underneath the exclusionary rule, and we don't want that to happen, especially if you find evidence that's very incriminating that can put somebody dangerous away in prison or in a jail facility. However, there are some exceptions. So generally when this happens, sometimes judges, they can say, hey, we're looking at the social costs. And that's saying they found these evidence that's so damning that they know if they were to deem this evidence as inadmissible, a dangerous individual can be released back into society. That's a cost and benefit analysis that judges, via their judicial review, when police violate the terms of a search warrant or conduct an unethical search, has to look at. However, if you feel like if you've ever been searched by a police officer or a criminal justice official and you feel like your rights have been infringed on, you can always submit an appeal for your case. Hopefully you enjoyed this video. I will be dropping another video soon, since I did drop this video kind of late this week, so definitely stay tuned, and hopefully you guys are still enjoying the content. And if you are a new student here, welcome to the channel. I'm so glad you enrolled in our class, and we'll be back with more criminal justice videos soon.